Thank you for attending or reviewing this video where we're going to talk about the source of agency power and specifically statutory delegation. And what we're talking about is under the principles of administrative law, how do agencies get their power? And then what extent, if at all, is there? What limitations are there on an agency or an executive body in the federal government in the United States? What limits might exist on its power? So we can begin by thinking about the amount of authority capable of being granted by Congress. So the first thing we can do is use this black bar here as a full spectrum and think about it and see those lines on either side as limitations. So we think of this finite space in which an executive body, and in this case, agencies, are granted authority. And just so we remember, or if we're thinking about this for the first time, the United States Constitution has three main articles where it creates government authority, and it has an express separation of powers within that creation of authority. Article 1, Article 2, and Article 3. Article 1 creates the legislature, our Congress, our United States Congress. They are the entity that is empowered to create laws. Article 2 is the executive. Most people think of the President of the United States, but the executive body is not just the president, but all of the administrative entities that exist. And this is not just at the federal level, certainly also at the state level for all of the states within the United States. But we can just focus on the federal level and think, so president and major executive bodies. And we can think of the Internal Revenue Service, the IRS, the agency that is delegated the authority and empowered to collect taxes on behalf of the United States government. The IRS, the Internal Revenue Service, the federal agency, it exists under an authority created by Congress, Article 1, under the Internal Revenue Code, the IRC or the Internal Revenue Code. That's the federal law that effectively creates both the Internal Revenue Service and spells out in that law all of its authority. And then the Internal Revenue Service is empowered by its enabling statute, the Internal Revenue Code, the law that enables it, creates it, and enables it to do all of the things that we know the IRS does. And we can think of many other examples. I focus on environmental issues, so big federal agencies, like the Environmental Protection Agency, for example, the EPA is a big federal agency that is empowered and authorized under a number of environmental statutes. And there's many different environmental statutes. You can think, for example, the Clean Air Act, the Clean Water Act, many, many others, the Endangered Species Act. But all of these environmental laws that are created by Congress under Article 1, generally, Congress doesn't say, we will do all of this ourselves. We will, not only enact this law, but then we will implement this law. Congress says, no, we're going to delegate that implementation to experts in the Article 2 executive agencies. And we can create these agencies like the Internal Revenue Service or the Environmental Protection Agency. And if they're already created, of course, and we pass another law that's within their realm, or we revise, like the Internal Revenue Code is revised a lot. So any of those revisions, we then simply delegate the authority for implementation of those new revisions or new laws, whether that's creating new environmental laws, for example, after the creation of the Environmental Protection Agency. Then Congress usually just delegates and enables that agency to implement the new law or the new version of an existing law if there's been some changes that are made. And then, of course, we have, if we think of the US Constitution, the third article, which is Article 3, which is our judicial branch of government. So you have your congressional legislative branch, Congress, your executive branch, all of the president, of course, of the United States, but all of the executive agencies and administrative agencies. And then you have the judicial branch. And the judicial branch's job is to determine both what is the amount of authority capable of being granted by Congress, because there are limitations. Congress doesn't have authority over everything. So the judicial branch tells us where that authority begins and where it ends outside of Congress's authority. And then it also helps us understand that within Congress's authority, in this case, the black line, whether or not, for example, an agency has, acted within the authority that has been granted to it by Congress, or if it's acted outside of that authority. Certainly, before we look at agencies, we can, as I just tried to summarize, we can say that there are acts that Congress, under Article 1, under its authority under the US Constitution, there are acts that it cannot take. And we can think of the Bill of Rights, the first 10 amendments, right? We can think of constitutional limitations as a starting point. So Congress, for example, could not pass a law that fundamentally violated a constitutional provision. Now, it's very unlikely that Congress would ever pass a law that on its face, in every way, would violate a constitutional protection, an individual right, for example, the right to free speech, the right to free expression, a number of the right to due process. It would be unlikely, highly unlikely. As a matter of fact, and this gets into a bit of detail, but there are ways in which the judicial branch looks at laws and interprets those laws, and it assumes in its interpretation that a law is made constitutionally valid, that Congress doesn't go about its business by creating constitutionally invalid laws on their face. But sometimes the way in which the law, otherwise constitutional, is being implemented, for example, let's say by an agency, it can go beyond the intentions of the law, and it can be outside of the authority or boundaries. So we start with Congress, and as we understand, we can understand that Congress obviously cannot create laws that violate its authority, can't go beyond that black line. If it goes into the beyond authority area, we understand Congress has no authority to do that. But again, it can happen, certainly can happen in theory. In practice, it generally doesn't happen, but maybe sometimes at local levels, some sort of local legislative bodies can create an ordinance in a municipality that is invalid, that is fundamentally constitutionally invalid. And that does happen. But let's say at the federal level, it happens a lot less because there's a lot of very smart people that are helping to develop these laws, these bills, and they go through a lot of review from a lot of different places before they're enacted. But again, theoretically, it's entirely possible that Congress could pass a law that's beyond its authority. But let's just say that for our purposes, most of the laws, almost all of the laws that the federal United States Congress passes are within its constitutional and other authorities under Article 1, within their capacity to do so. So then the question really becomes, when we say beyond authority, has the agency either done something in implementing the law that creates a constitutional question, or subservient to that, has the agency done something that is outside of its authority that Congress granted it? So what we mean here is that Congress, when it does pass a law, it generally passes a law that's within those confines of the black line, and it is some subset of the amount of authority that it's been granted. The law doesn't provide all powers that Congress is capable of doing, but it's some subset of Congress's authority. And so that green line that we see now gives us a sense of, okay, how much authority has Congress provided here in this particular law? When it creates the Internal Revenue Code, it gives the IRS a lot of authority both to collect taxes and enforce the provisions of the Internal Revenue Code. But that certainly doesn't go into things like what EPA, the Environmental Protection Agency, would do. You wouldn't see the IRS trying to enforce Clean Air Act standards, for example. Congress can pass the Clean Air Act. It's well within its authority. And the provisions of the Clean Air Act, as intended, are not unconstitutional as intended. Sometimes as applied, in a particular circumstances, they might end up being, but as intended, are certainly within the black line, within their authority, but they're not something that the Internal Revenue Service, right, the federal agents of the IRS, are really involved in. So the green line is meant to represent, okay, what is the authority that the agency has been given? And then, of course, in a particular instance, we can say, whatever the authority was given that's within Congress's authority, that's what the agency can do. But conceptually here, we can also say that there's a lot of things that are still within Congress's authority, but they haven't been granted to the agency. And that's what the red line is meant to represent for us here conceptually. That is the authority that is withheld from the agency by Congress. So we have instances where if we look at this, we can start saying, okay, if we review an agency action, if we look at an agency action, and if we can now sort of provide a framework and say, well, what is the authority that Congress is capable of granting? What is the authority that Congress actually granted the agency? And then what is the agency's action relative to that authority it was granted? And if it's in the green, then we can say that the agency action is within its delegated authority. So the agency is doing exactly what it can do. Alternatively, if it's in the red, then the agency action is outside of its delegation. Makes sense? Common sense. And this happens. Right now, we have examples where currently think of COVID. There's been a couple. So the authority for the federal government, for example, through an agency, not through Congress, but so not through the passage of a new law, but through an existing agency to claim authority in a way that it hasn't over an issue. For example, mandating mask wearing. That's been something, right? And I think mostly it's been through recommendations by the Centers for Disease Control, federal agency, CDC, but also standards set by OSHA, the Occupational Safety and Hazard Administration, another federal agency. Now, OSHA has an enabling statute. Congress created a law that created OSHA and gave it a number of powers under that law, the green. Same thing with the Centers for Disease Control. It has a number of authorities granted to it by Congress through legislative action in the green. The question is, when an agency decides to take on something new, for example, like we've never had, I don't believe, mask mandates, certainly not in our recent history from the creation of most of these agencies after World War II with an expansion, really during the New Deal post our 1929 into the 1930s, and certainly in the 40s, we had a wide expansion of federal bureaucracy for a number of reasons, FDR, the New Deal, and et cetera, so on and so forth. And a lot of complexities that happened after World War II that required a lot more federal interaction. But putting that sort of historical context aside, from the creation of most of these agencies to today, and the issues of whether it's a mask mandate or vaccine mandates are another one that has happened, whether or not the federal government can mandate for certain entities a vaccine. And you can see often the arguments that have happened over the last few years relative to, hey, this federal agency doesn't have, the federal government, and they're talking about the agencies because, again, Congress has not passed a law. It probably would certainly have the authority to, and that would make it clear. In other words, the authority to require masks or the authority to require vaccinations is probably, again, at its outset in the black line. It is authority that Congress has. Now, in a specific instance, it's entirely possible where somebody that has a well-founded religious belief, for example, that prevents them from getting vaccinations, so on and so forth, it is possible that there are constitutional limitations where, as applied, even though Congress has that authority, there may be some limit to the application of that legitimate authority to certain individuals and groups based on constitutional considerations. So you need to understand that Congress can pass a law that is absolutely constitutionally allowed. It's within the black, it's within its area, but as applied in a particular instance, there may be some question as to whether or not the law can be applied against certain individuals or groups based on some individual or group constitutional protections against certain government actions. Okay, but going back, and we can think about another example, something that's happening recently that's being taken up by the US Supreme Court is climate change and whether or not the Environmental Protection Agency has a wide authority, a wide-ranging authority to regulate against carbon. Now, carbon emissions happen in our, in our world. They happen in here in the United States in so many different ways. Carbon emissions is so closely tied to our economic activity, whether that's the production of energy, transportation. I mean, it filters everywhere. Carbon is everywhere. There was a case back in 2007, a US Supreme Court case where the Environmental Protection Agency, under the Clean Air Act, law passed by Congress, 1970, I believe, originally, certainly 1972, but there's been amendments and so on and so forth. But in the early 70s, passing of that federal law and granting the Environmental Protection Agency authority to both identify what are considered criteria pollutants that must be focused on and regulated by the agency against places like, energy creators, electricity generation plants, for example. So, if you're a power plant and you create electricity by burning coal, for example, or even natural gas, there's a number of, coal's been the sort of historical example, but there's a number of pollutants, things, they call them criteria pollutants. And in 2007, prior to 2007, the Environmental Protection Agency there was a question as to whether or not carbon itself could now be considered a pollutant under the Clean Air Act because of climate change, because of the effects of climate change. Now, carbon is everywhere. Carbon is not what you would normally consider a pollutant because it's naturally existing and it exists everywhere. And it's not something, we can take coal, for example, and we can burn it. And one of the byproducts of burning coal is there's sulfur. Western coal tends to have a lot of sulfur in it. That sulfur then mixes with the oxygen, goes through a pipe and becomes sulfur dioxide, and then it can catch into the precipitation and rain down as acid rain. And that can be it can have significant consequences for human health, for certain ecosystems. And so sulfur tends to be, or sulfur dioxide, and a number of others of things that are directly related to human health, directly or very closely related. Carbon has never been considered historically one of those things, but now with climate change, the question is carbon something that should be considered a pollutant? Well, during the end of the Bush administration, the EPA said we don't want to make a choice. And there was a famous case, or a relatively famous case, Massachusetts versus the Environmental Protection Agency. This Massachusetts was the state, but there were a number of states that were suing the Environmental Protection Agency because it chose not to decide whether or not to add carbon as a pollutant under the Clean Air Act. And the US Supreme Court at that time held that, it has to go through the process, that the Environmental Protection Agency simply can't decide not to decide whether carbon is a pollutant under the Clean Air Act, but it has to actually make a choice. When the Obama administration took over in 2008, 2009, they worked on creating a rule that included carbon as a pollutant, became a pollutant to be controlled by the Environmental Protection Agency. Fast forward now to 2022, and we have the United States Supreme Court going to take a case that has yet to be decided, where it's going to determine whether or not the Environmental Protection Agency can, in fact, actually use carbon as a pollutant, and whether it was granted the authority, because the effect of identifying carbon as a pollutant and then regulating carbon is regulating effectively almost all economic activity in the United States. In other words, if the Environmental Protection Agency can regulate carbon, then it effectively can regulate almost every kind of commercial activity, possibly all of interstate commerce within the United States, almost all of it, because carbon is ubiquitous in so much of what we do. And the question is, did Congress, within the world of the black line, right, what Congress is capable of doing, when it created the Clean Air Act, the green, did it intend for the Environmental Protection Agency, the agency, to be able to regulate carbon in a way that it had that magnitude of impact? Is carbon regulation, the EPA regulating all kinds of industries within the green, or does it step outside of the red? We don't know. I don't think we're talking about something that's in the beyond Congress's authority. I think we're talking about something of whether the EPA, it could regulate carbon if Congress gave it certainly explicit authority, which it has not. But if Congress did, I'm pretty certain that we'd be within the black and then within the green. We're not beyond the authority. But the question here is, Congress hasn't given explicit authority. And since it hasn't, and because of the magnitude of regulating carbon, giving that agency such expansive powers, does that move from the green to the red? Well, the answer to that will be forthcoming in I think the arguments will happen in the fall, and then maybe 2023, in the spring of 2023, we'll find out whether or not that's the case. I believe, but I haven't looked at it. Sometime in late 2022, or sometime in the first half of 2023. But anyway, that's something, if you happen to watch this before 2023 or mid 2023, that's something to really look at and keep an eye on. The point of all of this is to help you better understand, what does it mean when we talk about agency power, specifically statutory delegation? What does that mean in the context of our larger US system of our legislative, executive, and judicial branches of government, and the fundamental separation of powers doctrine? So in summary, always think Congress has the authority to do a lot. That black line represents a lot of authority, can do a lot of things. Not everything. We understand there's some beyond authority, but there's a lot of things. And then the question is, when it creates a statute, it usually gives an agency power for implementation, because Congress can't do everything. It doesn't have the expertise, it doesn't have the time, so on and so forth. So it usually delegates authority to the experts. The people that work at EPA are experts in environmental issues. The people that work at the Internal Revenue Service are experts in taxation, and you understand, right? And Congress isn't an expert. The folks that we elect as our representatives aren't experts in all of these fields. So they delegate the responsibilities to figure out and implement these things to these entities, these individuals and professionals. And the question is, when they create the law and when they delegate the authority, how much authority do they delegate? They can never delegate more than the black line, that's for sure. They can't delegate more than that. And usually they delegate a lot less. So when we think about agency power via statutory delegation, we're trying to determine whether or not the agency is working in the area of green, the subset of power Congress delegated to that agency, or is it stepped outside of that authority and is now living in the red? So I hope that helps you understand a little bit better about agency power and statutory delegation. Thank you.